There we go. Down in Clearwater, Florida, defense attorney Tiffany Simmons with us. Here in studio, Ashley McMahan, Brian Gaither, criminal defense attorneys, and trial attorney Randy Kessler. Welcome to you all. My question tonight for you, did Brittany Jacobs initiate this confrontation? Tiffany, let me begin with you down in Clearwater.
Hey, Vinny. No, she did not initiate this confrontation. There was no way for her to know that a gun would be pulled out and that her loved one would be murdered right in front of her eyes.
All right, Randy, what do you think? Did Brittany Jacobs initiate this confrontation? That's what the defense is arguing here. They're saying she's the one that elevates the argument. She cracks down the window, doesn't drive away.
What are you saying, showbiz? Stretch, right? That's a stretch. The fact that she parked in an illegal spot, is that, initiating a confrontation? No, it's something maybe she shouldn't have done. Is it she threatened to put her hands on it? It's not. She did not initiate this kind of confrontation. She might have initiated some frustration. She was reacting to being yelled at.
Ryan?
She definitely didn't initiate this conversation. He's the one who actually approached her. And it's funny because what the prosecution, what the defense is doing, they're trying to, literally, they have a smoking gun on video, literally. So they're trying to divert you from this smoking gun by putting it on Brittany, his wife. Of course not. He's the one that wanted to be RoboCop and go and enforce his authority on her. She's scared. She doesn't know what to do, and she's protecting her child. So I don't see how anybody's buying that.
Ashley?
Absolutely not. I mean, this is a woman, this is a mother. She's got young children in the car. And I don't care how many times you ask her, was she about to lay hands on this man? I don't blame her. When your maternal instincts kick in and you've got somebody that you think is threatening your children, you'd be surprised at what, a mother would do, even if she's smaller than this man and even if she doesn't know that he's armed. So absolutely not. I do not think she initiated.
Let me tell you, though, who's blaming her, Tiffany, in addition to the defense. I read all these comments on social media. We post a poll, we put questions, I post videos up there. And I'm not saying it's a majority, but there are enough people saying, why doesn't she just move the car? Why did she roll down the window and say anything? Why not just put the car in reverse, pull up to the front of the convenience store and wait for Marquise and her son, little Marquise, to come out?
Well, Vinny, I just want to say, why is she responsible for doing something different when she was going into the store just to get some items that she needed? It was not her responsibility to do anything different. He did not have to use this firearm. I mean, it's just simple as that. Blaming her, blaming the victim, that happens a lot of times in cases like these where it's high tension, high profile, so they don't need to blame the victim, especially the victim's family that's remaining.
Randy, the other thing that I'm reading and hearing a lot from the folks at home, our 13th juror, is she's the one making the threat. That she is saying, listen, do I need to get my man out here to mess with you?
The defense lawyer did a really good job of setting up her client and setting up the defendant as, oh, well, he didn't know that he was going to have this strong of a reaction. She led her right down the path to, yeah, my man was going to come out and beat the tar out of him. I mean, that's the way it came off. And the witness, the victim's, partner, basically was saying, yeah, I was mad, and she went along with the testimony. She was not a confrontational witness. She could have defended herself a little better and said, what'd you want me to do? I was trying to defend my kids. She went along, and she was coerced into basically saying, yeah, I did want him to come out and sort of beat the hell out of this guy who was yelling at me. That's almost what she said. So the defense counsel did a good job. It still doesn't win the case to me.
All right, we got a lot more to talk about, but I have a question for you tonight, our 13th juror question. It's about the opening statements. I mean, they were good, but which was better? Did the prosecution or defense have a better opening statement? I think you know my vote already, but I want to see your vote. Go to Vinnie Politan Court TV or Court TV right there on Facebook.
Force multiplier. He indicates Mr. McLaughlin never said one word. Never said one word. He indicates Brittany Jacobs during the argument said something about, you want me to get my man. And I think she acknowledges that, since she said that. You want me to get my man. But he says not one word. Mr. McLaughlin never said anything. They had no words exchanged. Mr. Drejka never said anything like stop. Never said anything. No matter what Mr. Shaw or the state says, there was no threats.
Mr. Drejka had a concealed weapon. He was allowed to have a concealed weapon. Not once did he ever take that weapon out or threaten anybody. Not once. Never threatened. Brittany Jacobs was in the car. Never said anything to cause any fear in her mind. Nothing. In fact, you will hear that at some point, Ms. Jacobs said to law enforcement when all this was said and done that she couldn't wait to get out of that car. She was going to lay her hands on Mr. Drejka too.
Now, both opening statements, both sides, good. But I just thought the prosecution was just, Fred Schaub took over that courtroom. And I want to show you two more examples of these opening statements just to show a little bit of the contrast between the styles of the prosecution and defense.
Drejka pulled out his gun. He was carrying a gun on a holster. He pulled out his gun. He was on the ground. He pointed that gun directly at Mr. McLaughlin. And watch carefully. We're going to show you a slow motion video, a portion of that. When he waves Mr. McLaughlin over, Mr. McLaughlin backs up. Mr. McLaughlin backs up as far as he can go, all the way to the car. He can't go back any further, and watch that video. He starts to turn away from the confrontation. And he's shot at that time.
You can see my style is a little bit more deliberate. I'm not going to rely on emotion. Because this is important. We're not driven by emotion, politics. We're driven by the facts. So bear with me if I take the time to look at my notes, but this is important. And as fact finders, the judge would expect the same of you. No emotion, just the facts.
As you can see, admittedly, different styles, but Fred Schaub just bigger than life in the well of that courtroom. So my question for my think tank tonight, did the prosecutor blow away the defense in the opening statement? Ashley, what do you think?
Absolutely. So what I want to call this opening statement, prosecution gave an opening argument. The defense counsel gave an opening statement. And as an attorney, as a trial attorney, you always want to be arguing your case until you grab those objections and you're told to shut up by the judge. So I think the prosecution did an amazing job.
Brian?
I think the prosecution nailed it. He painted the picture. He didn't only just tell the story. He actually showed you the story by getting on the ground. Now, it's circumstances because as a defense attorney, the facts, you know, when you see that video, you want to kind of gloss over that. So that's why he was like, this is not emotion. This is just, pure facts. However, he knows if he had the facts that the prosecution had, he'll be on the ground
He'd be doing the same thing. He'd be doing the
same exact thing.
Tiffany, what did you think?
Yeah, I was writing notes. I think that the prosecution did a great job. I mean, they have good evidence as well. That video evidence is clear. It shows exactly what happened. So, you know, the way that he laid it out was excellent.
Now, Randy, you also teach law. And I mean, and everyone you have to be yourself, right? So my guess is, Fred, that's just the way he is.
Right.
But from my perspective, the way he controlled the whole room and the way Chanley described how everyone is up just watching not even taking a note, just watching every movement, listening to every word. And the way he comes across as mastering the facts, but absolutely believing and invested in his case.
So some people have it. I teach jury trial, and it's a whole jury trial class. And sometimes there's students that are brand new law students that I think, man, I wish I could do it as good as them because they just have it. And this guy, he's got it, you know. And there's a saying that we talk about, when you got the law, you pound on the law. When you got the facts, you pound on the facts. And when you don't have either, you pound on the table. He was doing all three. I mean, he had the facts, he had the circumstances, he had the emotion. He would have made it on Broadway, too.
Now, the one thing I will say about the defense, I mean, they have to go second. So you have to follow that act. So I think it was actually a good move by the defense to not try to not try to outdo that, but go in a different direction, right? And
yeah,
that's what they did.
Good luck following that act. But I do have to agree. If they had, these are defense attorneys that are saying that the prosecution did an amazing job, and you know that we would all be hammering on the table if we had the emotional side.
And usually, in most of the cases that we cover, I would say probably 75%. Usually, the defense bar is a little bit more flamboyant, right? Mm-hmm. Exactly. You guys put a little more, gals put a little more into it, right? Here, when a prosecutor does it, it shocks me, but it impresses me. It does. Have you seen prosecutors like this where you practice?
Well, actually, I was one of those prosecutors.
Oh, okay.
I was a public defender for 5 years, and you really learn how to tell the story because you're taking your client's emotion and you're holding it in all these times where the prosecutor's not giving you good deals as that. So when I'm in trial, I'm gonna release all those emotions to the jury. And to see a prosecutor do that for like a victim is just amazing. And I did that all the time in court, where it's like the defendant's not trying to take responsibility, so all the emotions from the victim is about to go off on all the jury, and you'll see that happening.
Yeah, and a lot of it comes down to credibility, Tiffany, because at the end of the day, there's going to be two arguments, there's going to be two interpretations of the facts and of the law, and sometimes a jury will go with the person that they trust more. From the way these two opening statements went, who do you think created more of a bond with the jury?
I think right now the prosecution has created a bond with the jury, but I will add that the defense, they did a good job. They did a good job with laying out what they had and trying to be something that they're not by being flamboyant like the prosecution. That probably would have hurt them more than helped them. So again, you have to work with what you have. If you don't have the facts, you work with the law. And like Randy said, if you don't have that, pound on the table.
Now, I want to show a little bit more of the defense. And I've been talking a lot about the prosecution, but the defense was good. It's just sometimes one just kind of blows me away. But take a listen to Brian Camerino. He knows what he's talking about. Take a listen.
I want you to remember the rules, so to speak, is that you're the fact finder. Justice is blind, it's not driven by emotion. Politics, race, prejudice, bias, judgment tell you that doesn't come into play. The facts that they represented that day, the facts that they played in the mind of Mr. Drejka that day.
Randy, I think that's the best way to try to combat what Fred Schaub did in that courtroom.
And maybe he should have gone a little bit further and said, and at the end of the case, the judge is going to tell you what the law is. So you learn the facts, but trust me, at the end of the case, the judge is going to tell you what the law is, because the law does help them to some degree. You know, they've got to prove that he had premeditated this whole act and he premeditated murder, when it could easily be believed, yeah, he's the kind of guy that might shoot somebody, but did he really go there intending to kill this person? I mean, he didn't pick this person.
And the other part of it is they've got to, the prosecution has that burden of disproving self-defense. It's like proving a negative, which is not easy. So it's even more difficult in Florida for prosecutors to win a case like this, which is why you need an open like that, right?
Absolutely.
So how important is the open versus the closing?
I always believe that it matters, your opening matters as much as closing. I know most trial attorneys, such as myself, I'm definitely guilty of this, love to give a closing argument because it's the most fun part. I mean, you know, we can't lie about that. It is entertaining, and it's where you really get to hammer home your points. But the opening statement is really important because you're setting the jury up to know what they're going to hear and to know what they're supposed to look for. You tell them this thing that you're going to hear is important. This witness you need to pay attention to. This person you need to take notes while they're testifying. I mean, this is where you make or break your case.
And that's the other part of what Fred Schaub did in his opening statement. It wasn't just the dramatics, right? And sometimes I'm a little dramatic. It's not just the dramatics. It was also telling a story that made sense and was easy to follow. All right, here's my question. You saw him. Did the prosecution or defense have a better opening statement? You can agree or disagree with me, but tell me why in the comments. Go to Vinnie Politan CourtTV on Facebook or CourtTV on Facebook and vote on the poll and leave a note.
911, what is the emergency?
I'm at the Circle Food Store and someone just got shot.
The facts of this case can lead reasonable people to different determinations.
One thing you should know about this trial, very similar to the George Zimmerman case.
Marquise McLaughlin was a father. He was shot down in front of his child over a parking spot.
Michael Drejka appointing himself as the handicap parking police.
He is a dangerous man.
He shoves you to the ground. I'm on the ground like this. Okay. As I come out like this, he's taking his step. Okay. Was he charging after you? 2 steps running.
What happens if I told you that I looked at the video and in no time and point does he come running up towards you? He actually takes a step back.
I would disagree.
What did Drejka see? What did Drejka know?
When the jury looks at the video, no one's going to say it was unreasonable for him to have fired.
Drejka's history in uttering racial slurs will not be allowed in the courtroom.
All of America is watching Clearwater, Florida.
What does the jury need to find the truth?
He had to shoot to defend himself.
Should never have been prosecuted.
This is not right at all.
Those are the facts, and that's the law.
In his mind, he was defending himself. He could have walked away. Instead, he took a person's life.
Welcome back. Day one of the Michael Drejka case down in Florida. He's accused of manslaughter. He claims self-defense in shooting Marquise McLaughlin, who shoved him to the ground, pulls out his weapon. The prosecution says McLaughlin was backing up at the time that he shot. The defense says he had a right to fire his weapon to defend his own life at that moment. Now, this case, as you know, this case and every case in the United States, the defendant has a right not to testify. They don't have to present any evidence. They don't have to say a word, ever. It's up to the prosecution to prove the case beyond any and all reasonable doubt. And in this case, not only do they have to prove the case, manslaughter, they also have to prove that the shooting was not justified, that the self-defense does not apply to this situation. So you have to prove your case plus disprove the defense theory that it is perhaps a case of self-defense. So, as a prosecutor, which I was, which you know, that's the way I see the world and that's the way I analyze a lot of these cases because that's my experience that I bring here. When I tried a case, and you would never expect the defendant to testify, but you always prepared for it. And you wanted that moment because you as a prosecutor, if you're bringing that case, you believe you have the facts and you are convinced that that person's guilty. So if that defendant gets up on the witness stand, you as a prosecutor know that they are going to lie. And you're going to get a chance to cross-examine them and break them down and pull apart their statement and their story in front of the jury live. That's like a prosecution dream. Because if you don't think that the defendant did it, you shouldn't be trying the case, right? So if that person testifies, you as a prosecutor, in your mind, you believe and you know they're lying, I'm going to get to cross-examine that defendant. Well, most of the time, defendants don't testify. But the one situation where in most cases they do testify is self-defense. Because sometimes it's difficult to prove self-defense without the defendant getting up there to say and explain to the jury what they were feeling, what they were seeing, why they did what they did. Right? So this is a case where if I'm the prosecutor, I'm like, wow, you know what? I think we can force his hand and make him testify. He doesn't have to. But in order for them to argue and sell self-defense to the jury, you're going to need the defendant to tell his side of the story. But in this case, and I told you what a great opening statement the prosecutor made, I believe they may have made a huge mistake and repeated the mistake of the George Zimmerman prosecutors. Because in his open, the prosecutor said they are going to play the interview/interrogation videos of Michael Drejka, where he tells his whole story. Take a listen.
And he's asked, well, don't you think it would be smart to maybe call law enforcement? Well, by the time you get there, they're going to be gone. So, all right. That's kind of what we want. Then leave the spot? No, he wants to confront that person. Listen carefully to his statements. So we're going to play that for you. It's about an hour long. And then the detectives even have him demonstrate, when he was on the ground, how far Mr. McLaughlin was from him when he shot. Watch it. Look at it. He goes, oh, back up, back up. The detective backs up. Further? Yeah, further. The detective hits the wall. He says, I can't go back any further. Well, we're going to show you exactly the size of that room. It was 9 by 11. It was a 9 by 11 room. We measured it. And you're going to see that that was a 9 by 11 room, and he backed that detective up all the way to the wall.
You know what's going to happen now? The entire story of the defendant, his version of what he saw, what he heard, what he believed at the moment, is now going to be in front of this jury on videotape, meaning that Michael Drejka does not have to testify to tell his story. The defense does not need him to get on the witness stand. He will not be subjected to cross-examination, all because the prosecution is making it part of their case because they believe what he said is not credible, and the jury will see that video the same way they do. Same exact reasoning the George Zimmerman prosecutors used in putting George Zimmerman's video in evidence, because it doesn't get into evidence unless prosecutors put it in. Otherwise, to tell his story, he has to testify live. Let me show you part of the video that the prosecution is now going to show to the jury during this case.
So you're on the ground, right?
I'm on the ground like this.
Okay, how far is the guy away?
Front of the car.
He's at the front of the car?
Front of the
So he's on
car.
that sidewalk, kind of curb area?
No, he's in front of the car, off the sidewalk.
Okay, right on the edge?
You got it.
So how far do you think he's away from you?
I might have been right at the edge of the back of the front door.
Of the car?
Correct.
Okay.
All right.
So he's up by the front tire?
He's up by the front tires. No, further than that, man.
Further than this?
Further than that, man.
Okay.
I was back further. He had to be further than that.
Okay, so he's about this far?
Yeah.
Maybe even further?
And as I come up this way, because I have to come up off my hand, all right, I bring the gun out with me. And as I'm coming back this way, I can't support it, so I hit this.
Okay.
And as
What does he do?
as I come out like this, he's taking his step.
Okay. Taking a step?
Taking his steps towards me.
Okay, how close does he get to you before you fire the gun?
Maybe to the front tire.
So show me where, tell me when to stop.
Stop.
Okay, so right here.
Yeah.
Okay. Was he charging after you?
2 steps running.
Okay, well, you're saying he was running?
Well, it would have been running when he got out of behind the car.
Okay.
And yes, I know his version that he describes there is inconsistent with what we see on the video, but still, folks, I am scared. I believe this is a huge mistake for prosecutors if they're trying to prove this case. I don't think you need to put that video in to prove manslaughter. Make Michael Drejka tell his story live in court. But now that's not going to happen. So let me throw this out to my think tank tonight. Did the prosecution make a huge mistake here? Randy, what do you think?
So is the prosecution's case better if all they have is the video versus...
And the eyewitnesses.
Right, and the eyewitnesses, or the video and the guy's explanation? I think it's better without the explanation, period. They didn't have to give him that chance. It's like the kid saying, Daddy, let me show you this window that I broke, and let me explain to you how I broke it. Well, if you don't even say I broke the window, you don't get in trouble for it. They open the door. Someone that wants to find this guy not guilty or acquit him now has something to hang their hat on. They can say, I sort of believe him, or I'm not pushed beyond a reasonable doubt.
Yeah, there's no way he's testifying now, right?
Oh, of course not. I have to agree with Randy. They opened the door. And as a prosecutor, you don't get to cross-examine too often. So when you have an opportunity to cross-examine, you go for it. So if he says he was defending himself, well, get on the stand and tell the jury you're defending yourself. And I'm going to ask you questions about that. And now, potentially, that may have walked right out that door.
Yeah, I think that opportunity's gone. I don't think Drake is taking a stand. He doesn't have to if they played the interview.
I don't think he has to, but I'm going to disagree with my fellow colleagues here and say that he just might. And my reasoning for that is because of the other witnesses that we heard today. We heard prior bad acts from other witnesses showing that Drejka regularly approached people and threatened to shoot them just over parking in a handicap spot. So this is something that he has done before. And in that video, what we didn't see in that clip is that he admits to the investigators, hey, I'm not afraid because I'm always carrying. And I think that statement is really damning. And his defense attorneys, I'm sure, have gone over that statement plenty of times because it basically says he was not in fear for his life at the time, right after the shooting occurred.
Tiffany Simmons with us down in Clearwater, Florida. Tiffany, was this a huge mistake by prosecutors, or is this good evidence that'll help prosecutors in their case?
I agree with my colleagues. I think it was a huge mistake. Get him on the stand, make him say what he said in that video, if that's the truth, which we know is not the truth. I think it was a huge mistake using that video. The state should have kept that video out. However, it could be helpful if they do show the piece where he says, I was not afraid, I carry. That may help, the state.
Now, I always put a huge disclaimer at the end of making a statement like this, and yes, this prosecutor I have incredible respect for this team. They are obviously really good. We've seen that already inside the courtroom. They know the case better than I do. They know Pinellas County jurors better than I do. I'm just saying what I would have done and historically what I have seen. We even saw it right here in a recent case, Landon Terrell, where he gave a video interview inside that retirement home explaining his story. So the defense was able to argue his version without him ever testifying in court and never being cross-examined. As a prosecutor, I just hate allowing the defense to tell their story without telling their story. All right, let's talk about the opening statements. 13th juror question, did the prosecution or defense have a better one? Go to our Facebook pages, let us know. We'll be right back. Hey folks, make sure you go online, check out our Facebook pages and leave some comments. Like Melanie, great comment, Melanie. All right, folks, let's get back to work here. Prosecution made a great move, the way they opened their case. They opened their case not with this case and the shooting, but with an alleged prior bad act by the defendant. 5 months prior, same parking spot, same convenience store, but a different person parking in that handicap spot. And according to Richard Kelly, he was confronted by Drejka. Take a listen.
Did he appear to be looking inside your truck?
No.
All right. What did you tell him when you saw that?
I asked him, he stated that a family member, a mom or something like that is handicapped. I asked him, is your family member here at this time? He stated no. And
did it escalate?
Yes.
All right. Tell us a little about that. Was there cursing?
Yeah, it was a lot of profanity on his side. I said what I said and left it as that, and that's when he blew up.
Did you tell him why you were concerned about him being around your truck?
Yes.
All right. What did you tell him?
I let him know that we tote money in this truck and I don't need him walking around this truck.
At some point in time, did he indicate to you what he could do?
Yes.
All right, what did he say?
He said I should shoot you, kill you. I said, well, I'm not afraid to die. If you're gonna do that, well, he walked back to his vehicle. I didn't see any firearm, but he kind of walked back up on me. So.
At that point in time, did you feel like you might have to get into an altercation?
Yes.
Did you?
No.
All right. You never saw a firearm?
Never saw a firearm.
You saw him go to the car?
Yes.
Come out?
Yes.
You thought maybe an altercation?
Yes.
What happened then?
Then Ali came out the store and kind of like de-escalated the situation. Rick, just calm down. I said, you know what, Ali? That's what I'll do. Got in my truck and left.
All right, so according to Richard Kelly, Michael Drejka was talking about shooting him, all about this handicapped parking spot. Now, if the jury didn't believe Richard Kelly, his boss received a phone call from Michael Drejka, and he testified about it. Take a listen.
Did you ask him if he was handicapped?
Yeah.
What did he say?
He said no.
Did you ask him if anybody with him was handicapped?
Yes.
What did he say?
No.
All right.
So yeah, I said, was he preventing anybody at the time? And I kind of tried to explain that, you know, where that store is and where we empty our truck is directly, I mean, we're passing that store constantly. Our shop is a block away. A lot of times our guys, and for years, we would pull into that store, run in, get a drink, jump back out and go. Tried to explain that to him. Tried to explain that probably my driver didn't give him the most polite response when he came out of the store and he was up next to that truck, because there's money that's kept in that truck, and if you come up and there's a strange person walking around the truck, and you're gonna say something. I guess those two just didn't hit it off well. He told me that I was lucky. He said if I had a gun, he said I could have shot him.
Now here's why I believe this is so brilliant. Obviously it's an alleged prior bad act, very similar, but it also, now as the jury hears all the testimony about Michael Drejka shooting Marquise McLaughlin, they're listening to it through that filter. that this isn't the first time there's been a situation, a confrontation involving a handicapped parking spot and something having to do with shooting someone with a gun. So here's my question now, because the prosecution is attempting to paint a very specific picture here. Was Drejka itching to shoot someone for illegally parking in a handicapped spot? Let me bring back in my think tank. Ashley, what do you think? Is that picture being painted for this jury? Is it clear or is it not?
I think it's absolutely clear that that's the picture that the prosecution is attempting to paint, and I don't think they're having much trouble doing it, frankly, based on Mr. Drejka's own actions in this case. I mean, in Florida, so you can't present prior bad acts or improper character evidence just to sully the name of the defendant. However, there is an exception in Florida, and it's in Georgia as well. You can use it to show motive or modus operandi, and obviously this man was going out and he even told, you know, we've got race elements here too. It's always with an African-American driver. He is white. And then he calls, you know, this guy's boss and tells the boss, who is also white, you know, look, your guy was lucky because I could have had a gun on me and I could have shot him. I mean, if that doesn't fit this case and the facts of this case to a T, I don't know what does.
This is like prosecution one-on-one with similars, because a lot of times as a defense attorney, when the prosecutor says, I have similars, I might look at him like, okay, that's fine. You're just going to bolster it. And I'm going to flip it on you and say, you have a bad case. But here, this is when you actually do use a similar, where it's so spot on. You can show the motive. And now, as a defense attorney, this situation, this is when I tell my client, hey, I don't know. They literally got you doing the same exact thing, no matter what the circumstance is. It's a bad picture. So that's exactly what the prosecution's doing. And this is, other prosecutors need to take notes. This is how you use a similar.
You know, Randy, there's another part that the jury's going to see, and this may be another reason why they're putting in that video that I don't think they should put in, where Drejka says, I cleared all the legal hurdles. He talks about clearing the legal hurdles. So does that add to the fact that he's, you know, carries a weapon, he's allowed to, he's got his license, but he's always looking for a reason. For whatever reason, he has this thing about handicapped parking spots because of his girlfriend, former wife who passed away, who was handicapped. Was he itching to shoot someone here?
He might have been. And, you know, these folks are right, Ashley and Brian, right? They've left the defense with only one option, which is to say, if he wanted to kill somebody, why didn't he shoot the first guy? Why didn't he shoot the woman when she was sitting in the car? There was a legal hurdle, which is he had to feel like he was in danger or self-defense. And guess what? The defense might just have that because there is a video where he was thrust to the ground, right? That's the only thing that the defense has, because had he not been thrust to the ground, the last time he wasn't thrust to the ground, he didn't shoot somebody. Brittany didn't thrust him to the ground, he didn't shoot her. This guy thrust him to the ground, he shot back. So he thinks he was justified. He might have been planning it, he might have been, but maybe, just maybe the law's on his side. That's all the defense has.
Yeah, Tiffany Simmons with us down in Clearwater, Florida. Tiffany, is the prosecution being successful here in painting a picture of who this guy is? Now remember, in his opening statement, Fred Schwab called him this crazy man, right? Is this somebody who the jury may believe is just itching to shoot someone who has the audacity to park illegally in a handicapped spot?
I agree with the prosecution. He was itching to shoot someone. There is no reason that an argument or interaction about a parking space would end with Mr. McLaughlin deceased. There is no reason. So I think the state is doing a great job. The prior acts, using these witnesses to discuss his prior acts, I mean, it was spot on. I think they did a great job.
So what does the jury do here? Right? Because the jury, you know, they can't be emotional. They got to base it on the facts. They've got to look at this. But at the end of the day, don't they try to evaluate who this guy is and try to figure out what's going on there and answer the question, why? What's really motivating all these actions?
I think the problem is they've got to figure out, the jury doesn't know the law. They're not lawyers. I think they're all waiting for the judge to tell them what the law is, because everyone's got their biases or prejudices. Some people on the jury might say, hey, I like that he was trying to clear out that handicapped parking spot. Some people on the jury might say, I don't like any guy that shoots, and I don't like a white guy, I don't like who knows what their biases are. They're going to wait to hear what the law is, and if the law bolsters their opinion and how they feel it should resolve, they're going to go with their feelings.
But also, also to that effect, you know, the jury is going to be instructed by the judge in this case that would a reasonable person, a reasonable man standard in this same situation be in fear for his life that he thought it was appropriate to use deadly force here. And the prosecution is doing an amazing job painting a picture of what kind of man Drejka is. And I don't know that most jurors are going to say, hey, this is somebody that I would consider to be your average, everyday Joe, reasonable man making that decision in real time.
When it comes to the handicap spots, Brian, it can go two ways, right? On the one hand, he can be seen, like the defense says, he's almost heroic in that he is looking for people who are, you know, have no right to park in these spots, and he's kind of standing up for the rights of the handicapped who sometimes cannot do it for themselves, right? And that's what the defense is doing, but the prosecution is saying, no, this is a guy who is beyond that. He's obsessed with this whole handicap parking issue, and so much so that he's looking to take action against someone.
Well, and it's a very unique situation because typically it's the prosecution that has to rely on the facts and rely on the law, actually saying this is what the law is, A, B, and C. This is where the defense has to rely on the law, where it's like, yes, you know, he seems like he's going too far, but guess what? This is the law. This is what it says in Florida. You have to show that he felt that he was threatened for his life. So this is a very unique situation because now I really haven't seen a defense attorney have to kind of get like centered and say the law is A, B, and C.
You must follow the law, ladies and gentlemen. All right, great opening statements today. 13th juror question. Did the prosecution or defense have a better one? Let me know, yes or no. We're getting close to revealing those results, so get your vote in now, please. This case is about that video and what happened in that video. Obviously, there is testimony and eyewitnesses surrounding all of that. You're going to hear from experts as well. But when you get back to the video and everyone looks at it, you see what happens. And a lot of people are wondering, Marquise McLaughlin, who comes out of the convenience store, and there's that confrontation going on between Brittany Jacobs and Michael Drejka. Why does he shove Michael Drejka? Why? What was it that he heard or saw that made him shove Michael Drejka? Well, that question may have been answered today by a witness. His name is Robert Castelli, and when you watch the video, he's the guy in the blue shirt who pulls up and sees something going on, hears it, notices it, but then goes into the convenience store. And today he testified about what he saw and what he said when he went inside the convenience store where Marquise McLaughlin was with his 5-year-old son, little Marquise. And the key word that I heard was altercation. Take a listen.
When I opened the door, I told the clerk that there's an altercation outside. You might want to get involved.
All right. So when you opened the door, did the volume of what was happening outside change in any way?
By the time I got out of the car and the window was down, it was an all-out screaming match.
All right. So very loud.
Yes.
When you went into the store, could you hear the defendant's voice as well as the female's voice?
Yes.
And then you went and you told the cashier, and again, what did you say?
There's an altercation outside. You might want to get involved.
While you're in there, can you hear both the female voice and the male voice?
Yes.
You're outside. Do you see the black male push the defendant?
Yes.
Prior to the black male pushing the defendant, does he scream any threats? And by he, does the black male scream any threats to the defendant?
No.
Does the black female go up and try to attack the defendant?
No.
Right before the black male pushes the defendant, what's the black female doing?
She was just standing there.
All right. And once the black male pushed the defendant down, did anyone say anything at all to anybody?
No.
Was it completely quiet?
Yes.
So obviously there were no threats?
Nope.
The defendant's not saying anything at all?
No.
So that word altercation, right? And I think it may mean different things to different people, but when I hear that word, to me, that's, you know, you can be more specific and say physical altercation, verbal altercation, but when you just hear altercation, I'm presuming that there's something dangerous happening there, that there's a physicality to all of it. And I'm wondering what Marquise McLaughlin thought when he heard that word. We know what he did when he heard that word. That's when he leaves the convenience store, exits. He's right near the cash register, exits, and makes a beeline towards Michael Drejka and shoves him. Okay? So a question I have for my think tank, was Marquise McLaughlin justified in pushing Drejka? Ryan Gaither, what do you think?
Honestly, when he pushed him, we can consider that a simple battery. In a lot of jurisdictions, provocation is a defense to simple battery. So you can make an argument that when you see your woman, your wife being harassed, you're provoked, so you use reasonable force to push the threat away. So technically, he could be justified for pushing them.
See, I think with the word altercation, the first thing that comes to my mind, and this may be a product of having been a prosecutor in the beginning of my career as well, and when I hear somebody say the word altercation combined with the words, you may need to go out there and get involved, that says to me that's a physical fight, not just, two people yelling at each other or a road rage type of situation or something like that. That says there is a physical threat to somebody. So in my mind, when, and this is just from my experience, when Marquise heard these words, my thought process is that he's assuming there's a physical fight and a physical threat to his girlfriend outside as soon as he comes out. So I think in his own mind, he may have been justified in pushing Drejka to the ground, but that may not be borne out from the evidence that we see on the videotape based on what was actually happening.
I think a lot of people would say Drake had it coming to him, right? What he did deserves some sort of feedback. But that's not the question. The real question, it's sort of, I hate to, make it like this, like the metaphor should be road rage. Someone cuts you off, you have a right to honk your horn and flip the finger at them, but you do that and all of a sudden the guy pulls a gun. So safety's best, Yes. In hindsight, I'm sure everybody wishes he'd walked away and not pushed him. But in the heat of the moment, boy, how would we act?
Tiffany Simmons down in Clearwater, let me put a little bit of a twist on this now, just a little bit of a twist. Let's say that gun is never fired. Could you defend Marquise McLaughlin if he got charged with assault based upon the facts up until that point?
Yes.
How?
Yes, because again, he thought that his fiance or girlfriend was being assaulted. He wanted to protect his family. So I would be able to defend him. I definitely would defend him in this case.
Now, from my perspective, this is going to be a huge fact in this case, and a huge part of this case is that there's nothing physical happens until Marquise McLaughlin exits and shoves this defendant. How much of a problem is that for the prosecution?
I think it's a big problem for them. And because so much of this case is just about the subjective viewpoints of all the parties involved, okay? The only objective view we have is this closed circuit TV camera. But even in watching that, you don't know what is going through Drejka's mind, which if he doesn't testify, we may never really know what's going through his mind, even at this point.
You thought he got hit by a 2x4 from behind.
Yes, but I don't know if that's the most reliable or believable explanation.
That's what he said on the video. That's going to be in evidence.
Yeah, but we also don't know and we'll never get to know, unfortunately, what Marquise was thinking when he's running out and when he sees this altercation happening and this fight going on. So, we're left with a lot of questions here that unfortunately, even at the end of this trial, still won't be answered for a lot of people.
This is a big fact for the defense, don't you think?
Yeah.
This is a huge part of their case.
It is. Defense counsel has to own it. They have to stand up and say, let me tell you what, there's some things this guy did that even I don't like. He was in there. He should have said politely, please back your car up and don't park here because there are people that need to park here. He should not have laid into her. He should not have yelled at her. What he did was wrong. It was bad. But that didn't justify him being pushed down. When he got pushed down, that changed the game. That's what defense has to do. They can't say he's this innocent bystander who just happened to all of a sudden fall into this situation he had to defend himself. He's got to own his flaws.
And the prosecution, basically, they're battling between the primary aggressor being the victim, being a primary aggressor or self-defense of others. Because when he came out and it's an altercation and you see your wife there, you can argue that he was defending his wife and he's being provoked. But the problem is he made the first push. So that first push, now if the victim is the primary aggressor, things does change. Yeah. Legally and factually.
Tiffany, how does the jury interpret all of this? How do they interpret? And it really gets back to the first question we had, which was, did Brittany Jacobs initiate the confrontation? Did Marquise McLaughlin initiate the confrontation? Is there a possibility that the jury looks at it that way, that he is the aggressor, he takes it from a level down here all the way up to a physical level up here, and that becomes a problem down in Florida.
Well, Vinny, even if Marquise did not push Drejka, he still pulled out a gun. He still shot him. He still ended up killing Marquise. So at the end of the day, I still look at the fact that Drake is the defendant. He is the primary aggressor. He had a gun. He was just waiting to harass someone. He was just waiting to use it. This situation, regardless of what Ms. Jones said, it doesn't rise to the level of, I need to shoot these people. He wasn't in fear of his life. He wasn't concerned about his safety, because if he was, he would have just minded his own business. It is unfortunate that a person has lost his life due to over a parking space.
I think the jury's just going to say, Drake, that's what he wanted. He did want to shoot somebody. I mean, the prosecution's painted the picture, and I think the jury's going to think this guy was sitting there, and when he got pushed, in his mind, he thought, now I got it. Now I got the chance to do what I've always wanted to do. And because of that, I think he's going to get found guilty. But, you know, case isn't over.
No, it's far from over, and we're going to hear the defense case. They may have some experts talking about perception and everything else, and how you are supposed to react to all this. From his statement that we understand will be in evidence, he says that Marquise McLaughlin is coming towards him, that the threat is getting greater. He concedes that he's 10, 12 feet away, but he says he's coming towards him. The video shows something else. Is there any way that the jury may think, well, maybe he thought he was coming towards him, so they cut him a break, that he thought the threat was ongoing because he's the victim of the first initial physical part of this confrontation?
I mean, that's definitely the risk that, I think the prosecution takes in this case, because juries have done that before. And this is a case that is going to be heavily divided, not only on racial lines, because you've got an all-white jury, you have an African-American victim and African-American witnesses and a white defendant, and whether or not we want to admit it, it's going to be divided along political lines as well. People that believe heavily in the Second Amendment and the right to carry guns, and there's been a lot of gun violence in this country in the recent headlines, that they're going to have to address and be aware of when they're trying this case. And people that believe that, nobody should be allowed to be carrying a gun to avoid specifically these type of situations. So it's going to be a real sticky situation for everything that's going on right now.
The other part of this is you talk about gun ownership. And one of the jurors is an NRA member, and that came out during voir dire. But a lot of times, members of the NRA will look at a situation much differently because they've been trained. They are responsible gun owners. They know when you are and are not supposed to use that type of force. So is it possible that perhaps a gun owner is actually better for the prosecution because they may look at the situation and say, no, you don't use a gun under those circumstances?
Absolutely, because typically they would know, like you said, when you use a gun, when you use force, and when you don't. And they can have a whole different vantage point because first thing, particularly politically, they want to protect their Second Amendment. Right. So if you're somebody that's not doing it, they're like, oh, hold on, time out. We're legal gun carriers. We know when to use our gun. This guy, I would have never done that. So yeah, it really could help the prosecution.
I mean, guys like that are going to make people vote against gun ownership. And now if we let guys like that walk around on the street, then I'm not going to get to carry my gun, which I do in a legal and proper manner.
Yeah. Something else, Tiffany, that I've been reading a lot on the comments on social media. Folks, I do read them. Talking about getting back to the videotape and what some people are seeing and what others are seeing. And some people are seeing after the shove that Marquise McLaughlin continues to take a step or a step and a half towards Michael Drejka until the moment that the gun is exposed, and it's not until the gun comes out that he backs up. And some people are saying, well, wait a minute, he is going after him until that gun comes out. And that may be proper use of the gun.
I don't think that it was proper use of the gun. Marquise did what any reasonable person would do. If a gun is being pointed at you, you're going to run, you're going to leave, you're going to try to get away from, the situation. So I believe Marcus did exactly what a reasonable person would do. I believe the jury is going to look at the facts of this case and look at what a reasonable person would do on both sides. Although Marcus, he did push the defendant, that doesn't rise to the level of him losing his life.
And there, Randy,
Now,
we were watching the video there for a moment. After the shove, you can see, especially in slow motion, which the prosecution will be putting in, he does take those 2 steps. It's like 1, 2 steps closer to Drejka. Watch. Let's watch it. This is regular speed, I believe. This will be regular speed. Watch the shove. 1, 2, and 1, 2, 3 back. 2 forward, 3 back.
This is why this is a fascinating case and why you're covering it, why so many people are watching it, because both sides have an argument. The prosecution's going to say, look, ladies and gentlemen, he acted just like all of you would. You take 2 steps back. And the defense is going to say, look, ladies and gentlemen, he acted exactly the opposite of the way you all would. You guys wouldn't come up and push somebody down. So which side do you buy? I mean, it depends maybe on your prejudices and biases coming in.
How do you interpret that? 2 steps forward, but then 3 steps back.
It's a tough one because, like I said, the defense is going to argue that he took 2 steps forward to continue the attack. But of course, when he pulled out the gun, he started retreating. And we know technically you're not really supposed to shoot somebody as they're retreating. So it just depends on how the jury's going to interpret that. And I do not envy the jury on this one.
No, it's a tough call. The video is there, but the video is being seen differently by different people right now.
Those 2 or 3 seconds between him taking the steps forward and taking the steps back are going to be the only seconds that really matter in this case. And I think the prosecution's doing a great job of painting a very good picture of what kind of person this defendant is, so that when the jury is looking at those 2 to 3 seconds that matter the most, they're doing it through the lens of, is this a person who is seeking out this type of behavior?
You know, we've all tried jury trials, and the funny thing is, or the interesting thing is, at the end of a jury trial, if we get to talk to the jurors, what we always hear is the jury doesn't deliberate until the end of the case. And when they start deliberating, it's like they all saw 12 different cases. You know, you think they're
it's
all
like eyewitness testimony. All right, 13th juror question. Did the prosecution or defense have a better opening statement? Results are coming up, so get your vote in now. Vinnie Politan, Court TV, or Court TV on Facebook.
What we're on trial for today is what he did to Marquise McLaughlin. You're going to hear that Mr. McLaughlin was unarmed. No knife, no gun, no weapon of any kind on his person.
I'm not blaming you, that's not blame. I'm here to explain. There's justifiable homicide, there's excusable homicide, and then there's self-defense.
What did you notice, or what caught your attention?
The same vehicle in the parking lot that I had an altercation with. He said I should shoot you, kill you. I said, well, I'm not afraid to die. If you're gonna do that, well, he walked back to his vehicle.
This isn't a one-off, right? And it started 5 months prior. So you definitely want to set the scene and have them have this image of who Drejka really is.
And tell the jury, why was it that you are now getting loud?
Because I just wanted this man to just leave me alone, just leave me and my babies alone.
In fact, you actually said that you were about to put your hands on him.
Yes.
Right? That's not the statement of a person who's scared, correct?
I mean, yeah, I was so scared because I wanted him just to get away from me and my babies.
But a person who's scared doesn't say that they want to put their hands on somebody, right?
No.
Were you concerned for her?
Yes.
Why was that?
Because he was shouting very loud, and I could tell he was very upset. He was in a threatening manner towards the car, pointing at the car, yelling, screaming. I would consider that threatening.
Can I come out and check on the kids? It says very hot and the windows rolled up, and he said, sure, yes, come on out, everything's fine. They have it on video, I'm just waiting for the police. And then he just very calmly, he stated everything very calm, almost proudly.
Is that sign a legal sign, so to speak?
No, sir.
All right, and why not?
Basically, the way Florida state statute reads, the sign itself has to obviously have the wheelchair symbol on there, and there has to be some very specific language written on that sign.
In his testimony himself, the altercation, and not just with Richard Kelly, but he called his boss, Kelly's boss, the next witness, John Tyler, and talked about how Kelly in the altercation, now that he didn't threaten John Tyler, that was clarified, but still it was a big deal, so much so that the owner of the convenience store, who also testified, told Drejka to calm down, quit getting in these, quote, stupid fights.
All right, results are in for our 13th juror question. Did the prosecution or defense have a better opening statement? And the prosecution coming in at 72%, but the defense 28%. That is not bad at all, especially in light of what Fred Schaub did inside that courtroom. So the defense holding their own, but the prosecution winning with our 13th juror tonight for opening statements. But there was a lot more that happened today. A lot of testimony, a lot of witnesses, cross-examination, big, big day. Let me bring back in my think tank and ask them who had a better day. Prosecution or defense will begin in Clearwater, Florida with Tiffany Simmons. Tiffany, who had a better day?
Of course, the prosecution had a better day. They had great witnesses. They had a great theme of the case. They had good facts. I mean, to use witnesses that were not connected to Marquise, not connected to Ms. Jones, that was great because they were able to paint the picture of who this defendant was, and he was a man with a gun looking to kill someone.
Randy Kessler, who had a better day, prosecution or defense?
Prosecution. I think you influence the viewers. You're just so believable, damn it, Vinny. But I think the bottom line is when you have a defense counsel get up in an opening statement and say, well, I'm not going to get all emotional. He's basically conceding that the prosecution got the jurors on his side, and so we're not going to get emotional. He can't go toe-to-toe with them on the facts or on the emotions, so he's got to sort of distance himself. That, to me, says prosecution obviously had a better day.
Brian Gaylor, prosecution or defense?
Man, the prosecution, they scored a big touchdown with that similar because it really painted the picture of who the defendant is. And it's a perfect storm. You have the facts, the emotions, and the actual similar that matches prosecution.
Ashley McMahan,
Prosecution all day long, if only for that opening argument. That's what I'm going to call it forever. Opening argument. It was fantastic.
All right, Chandler Painter has a look at what's coming up tomorrow.